There we go. Last time we talked about legal research and that it is the investigation for information necessary to support legal decision making. We discussed the sources of law and the fact that the term sources of law includes the origins of legal concepts and ideas and the governmental institutions that formulate the legal rules and the published manifestations of the law. We discussed the nature of legal authority and that the term authority applies to both the type and the persuasiveness of the material. Hello, Sarah. We discussed the fact that there are primary and secondary authorities, and that primary authorities are authorized statements of law by the government, and that secondary authorities are commentary about the law that are used to explain, interpret, develop, locate, or update primary authorities. We discussed that authority also discusses the degree of persuasiveness and that some authorities are binding or mandatory and others are persuasive. We discussed the fact that secondary authorities are always only persuasive and that primary authorities can be binding but are not always binding or mandatory. It depends upon the specific circumstances. We then proceeded to discuss the different development of law in this country, and we discussed the development of the common law, also known as the law of the case. And we discussed the difference between common law systems and civil law systems, that in a civil law system, there is a presumption that there is a provision in the code and the statutes for any legal question, but that in a common law system of justice, there is no such presumption. And then in discussing case law, we discussed the structure of the court system, that is the hierarchical structure of the courts, looking at the three levels of courts on both the state and the federal side, that the federal courts consist of the U.S. district courts at the bottom, the trial courts, the U.S. courts of appeals in 13 circuits in the middle, that's the intermediate appellate courts, and the U.S. Supreme Court at the top. And that on the state side, we have three levels of trial courts in Texas, justice and municipal courts in the middle, constitutional and statutory county courts, and the highest level of trial court is a district court. The intermediate appellate courts are called the Texas Courts of Appeals, and the highest court in Texas is actually two courts that we've divided the jurisdiction between civil and criminal. The highest civil court is the Texas Supreme Court, and the highest criminal court is the Texas Court of Criminal Appeals. After we discussed the structure of the courts, we then discussed the doctrine of following precedent. And we talked in specific about three particular Latin terms that I wanted you to be familiar with. Welcome, Melody. I've got you on the roll. Thanks for letting me know. The three terms are stare decisis, ratio decidendi, and dictum, or obiter dictum. We discussed the fact that Starry Decisis, which means to stand on things decided, is the principle under which we follow precedent. That is, we have a doctrine of a court making a decision, and that decision then being binding on that court and on the courts, the lower courts that report to that court for disposition of factually similar controversies. We discussed ratio decidendi, and that the ratio decidendi in a case is the holding or the principle of law on which the case is decided. And finally, that dictum or obiter dictum is additional language in the opinion that is not necessary to the decision, but that may be persuasive in future cases. It's the language where the court says, oh, and by the way, we know we settled this case on this other issue, but if we had gotten to the additional issues raised by the appeal, this is what we would have done with these if we had gotten to them. It's sort of coming attractions. It's information when you have sent a case back for further proceedings for the court you sent it back to know what to do with the other things that they may have done wrong in the original trial. But it is also information to future litigants about what the court is likely to do should such a question arise again. And so to that extent, we say that yesterday's dictum is tomorrow's ratio decidendi. When a court gives you insight into how they are likely to act on a matter, it is not uncommon for them to then, in fact, take that action, either in the same case when it comes back or in another future case where similar issues of law arise. And so dictum can be important because it gives you insight into what the court is likely to do. Does anyone have any questions about any of what I just went over, which is a summary of what we discussed during the last class? Very good. I always like to do a review at the beginning of each class, and you'll find that at the beginning of each lecture, I will do a quick review of what we covered in the previous class in order to ensure that there weren't any questions that arose after class where when you were rereading the book or looking at your notes or listening to the lecture again, something suddenly occurred to you and you now have more questions than you thought. I always like to give people the opportunity to ask another question in that regard before we move on to anything new. Just to give you a sense of my process as we're going along. Okay, that brings us to legislation and the interpretation of statutes. And for those of you following along in the book, we're at the top of page 7, or almost the top of page 7. A statute is a positive statement of legal rules enacted by a legislative body. A legislative body is an elected body empowered to write laws. When we collect statutes and we arrange them by subject matter through a process known as codification, we create something called a code. Statutes and codes are two different words for essentially the same thing. Law written by the legislative branch. These statutes and codes have become very important even in common law systems, The law in this country is a combination of statutory law and case law and administrative law, which we're going to talk about in a minute. It's important to note that in England, the earliest statutes were enacted by the king with the concurrence of the King's Council. Later, the role of statute maker was assumed by the Parliament, and in this country, statutes are enacted by the legislative branch and then signed by the President. The federal legislature is Congress. The state legislature is called the state legislature. That's the state house and the state senate. It needs to be noted that most statutes are written for general circumstances or general, almost generic problems. But court cases are made up of specific parties and specific facts. When a court is called upon to apply a particular statute to a particular set of problems or questions, statutory interpretation is necessary to determine whether this individual law should apply to this particular set of facts, to this case. And so in that matter, statutory interpretation becomes important. Statutory interpretation can take several different forms. Sometimes the court will look to the intent of the framers. What did the people who wrote the statute intend for it to do? And they look at that intent by taking a look at what we call the legislative history. How did the original bill differ from the bill that ultimately was enacted into law and signed by the president? What did people say on the floor of the House and the Senate as the bill was being passed? What reports were issued by the different congressional committees that considered the law about the force and effect of this law and how it's going to work? All of those things make up legislative history and is part of statutory interpretation. In addition, courts may utilize strict constructionism to look at the plain meaning of the statute based upon the words that are used and giving them full force and effect based upon the current usage of that language, as well as the usage at the time the law was passed. So it can vary greatly as to how the court may choose to interpret any given statute. So statutes have become important, but in addition, figuring out how to interpret those statutes and when and how to apply them to individual facts means that even where the law you are applying comes to us from the legislature, we are still asking the courts to figure out how to interpret the law. The third branch of government, excuse me, is the executive branch. And the third major institutional source of law is also the executive branch. The law written by the executive branch on the federal side includes executive orders from the president, rules and regulations from administrative agencies, and decisions made by administrative agencies empowered to make decisions. On the state side, that's executive orders issued by the governor, rules and regulations and decisions issued by executive branch agencies. It's important to note that just as there are rules for how statutes are passed and sent to the president for signature or veto, and a vetoed statute may be put into force and effect if you get an override of the veto. That is a supermajority, 2/3 majority to override the presidential veto. So too, there are limitations on executive orders and administrative action through rules and regulations. Specifically, there are some areas of law where the executive branch has no purview. Only Congress can decide what taxes people are asked to pay. Only Congress can set the tax rate. Only Congress can decide to repeal taxes or to waive the payment of taxes. The executive does not have the power to issue an order creating a tax holiday, as it were. The executive branch and the chief executive does have the power to issue an order pertaining to the collection of taxes. So the president did have the power and did sign an executive order that said starting September 1, which by the way is today, people don't have to pay withholding tax. President didn't have the power to say you won't owe the tax later, just you don't have to pay the tax now. However, to implement the presidential executive order, the agency to whom the order was directed, in this case the Internal Revenue Service, is required to issue rules and regulations for how to carry out this executive order. And currently, they haven't figured out what to tell people, or more specifically, what to tell individual companies. At the moment, they are giving individual companies the option to either choose to continue to withhold taxes or to put withholding tax in abeyance and not pay them until after the first of the year. The problem there is that everybody's going to end up owing a lot of taxes next year on today's income if they're not paying in as you go through over time, unless Congress were to act to waive the payment of those taxes. For those of you who received a check from the federal government earlier this year as relief from the pandemic, you need to understand that that check you received was an advance on any tax refund you might receive when you file your 2020 taxes next year. In other words, they just gave you your money back early. But if it turns out that you weren't going to get a refund that big, you are going to owe some of that money back to the government because they didn't change the tax rate. They didn't change the taxes you were owed. They just gave you, yes, that $1,200 was an advance on a tax refund. It was paying you back some of the money you had already paid in withholding, which is why a lot of people have started withholding more money in order to try to turn, to not have penalties or interest or problems when they file their taxes next year because of this tax holiday or tax refund or payments you received. The extra money people received when they filed unemployment, that's a whole different thing. You don't owe that money back. Unemployment payments were just that, payments because you lost your job. So if you received the extra money because you were unemployed under the CARES Act, that's money you received and you can keep. You may owe taxes on that money. That's a percentage of what you received, but that was not refunding your own money to you, but the $1,200 was. And it's just important for people to know this because a lot of people thought that was a gift, government paying them money because it was a hard time and a difficult situation, when in reality it was just an advance on the any refund that you might receive. Actually, some members of the media tried very hard to make clear this was an advance. Yeah, nothing in life is free ever. If the person's now deceased, their estate still owes taxes for any income earned during the year in which the deceased person died. Just because you died doesn't mean you don't pay taxes or have to pay taxes. What is interesting is that there are individuals, because they based who got the $1,200 payment on people who paid taxes last year, the government actually wrote checks to people who were dead. And then they had to try to figure out how to get the money back from their estates, because even though they had been notified that people were deceased, they didn't match up their databases, and so they sent checks to tens of thousands of dead people, some of whose heirs ran out and cashed the checks fast. It makes for interesting times. The executive branch is empowered to carry out the law. It is their job to implement the law as written by the legislature. So when the legislature empowers the Social Security Administration to collect money toward a Social Security pension and to pay money out of the Social Security program to retirees or to individuals who have paid into the system and now become disabled, the Social Security Administration is responsible for writing rules and regulations and creating forms to effectuate applying for those benefits and being sure that you can collect the appropriate benefits. They do this through rulemaking. The key thing to understand about the laws passed by the executive branch, that is, administrative rules and regulations and executive orders, is that executive orders pertain only to orders from the president to other agencies in the administrative branch. The president can't issue an executive order to Congress to do something. The president can ask Congress to consider legislation, but that's not an executive order. When the president issues an executive order to an agency, it is then up to that agency to try to carry out the directives of the executive order, but they must do so in a manner that is in keeping with the law as it pertains to how administrative rules and regulations are created. That's the Administrative Procedure Act and the Regulatory Flexibility Act. Under current federal law, if any executive branch agency wishes to write rules on any subject, they have to put on a calendar that is published twice a year, in April and in October, that they intend to engage in rulemaking of a certain type, that is, rules pertaining to a particular subject matter, and when they intend to implement those rules, when they intend to promulgate those rules and put them out for comment. Then they have to write the rules and they have to publish them in the Federal Register and put them out for comment by ordinary people. And they have to stay open for a certain period of time. And then once the comment period closes, then they have to review all of the comments and revise the proposed rules based upon the comments, and then they have to republish the rules in final form, and they have to have been published a minimum of 30 days, and depending on the subject matter, the law may require a minimum of 60 or 90 days before the new rule goes into effect. This has been a situation that has been very, very frustrating to our current president. In his prior dealings, in his business, when he told people to do something, they did it. There were no rules and regulations about the time limit or how much they did or how they had to jump through certain hoops to get something done. He said, do this, and people did it. He is now very frustrated by the fact that he's issuing an order for people to do something and nothing's happening. Because the way the Administrative Procedure Act works, you have to go through very specific actions and they take time. And when his administration has failed to follow the rules, it has hurt them. Most recently, in the last session of the U.S. Supreme Court, one of the decisions issued toward the end of their term had to do with the Daca program. The Daca program was created through an executive order by President Obama, and then implementation through rules and regulations through Customs and Immigration and Customs Enforcement. Those rules and regulations were properly promulgated over time with opportunity for comment, and then revision, and then publishing, and then they went into force and effect. President Trump said, if Obama can issue an executive order creating the program, I can issue an executive order terminating the program. And he did. And he told that order terminating the program instructed the same agency to terminate the program. The problem is that the person who was in charge of the agency, in their desire to implement what the president asked them to do as quickly as possible, failed to follow the rules. They didn't do all the things required to ensure that the actions they were taking were done in full conformity with the required statutes. And so very recently, the U.S. Supreme Court ruled that the action taken by the Trump administration with regard to the Daca program violated federal law and that their termination of the program could not stand. They didn't say he didn't have the power to terminate the program. What the court said was they didn't follow the rules. They didn't do the things they were required to do in order to be able to terminate the program. And since they didn't do what the law required, their attempted termination of the program was not acceptable, was not lawful, and that the program had to go back into existence unless and until they changed what they had done before, and they did so utilizing the requirements under the law. As it is, they've said they want to take another run at terminating Daca. The problem is that the next calendar for rulemaking is published in October. Even if they publish in October, that in October or November, they're going to write new rules pertaining to the program. Those rules will have to be published, and they'll have to be put out for comment for a period of time. And then after the comments, they'll need to be revised, and then they will need to be republished. And then they will be have to have been published a certain period of time before they go into force and effect. Well, by the time they put it on the calendar and they actually write the new rules to have them published, it will not only be after the next election, but in all likelihood, the soonest they would be able to enact something and have it actually go into effect would be after the inauguration of the next president, whether it is an inauguration of the current president or an inauguration of a new president. And so in all likelihood, they will have to start over again. Administrative law is the executive branch carrying out what they've been told to do, but they still have to follow the rules. And so that has created a pretty complicated area of law. It's important in that you have individuals who nobody elected writing rules that have the force and effect of law, but you also have to dot the I's, cross the T's, do all the things required under the law, or you cannot carry things out. Essentially, if Trump wins, his Immigration and Customs Enforcement Agency can continue the timetable that they set in October if they put it on the timetable on the calendar in October to try to repeal the program. If, however, they don't get through the rulemaking process and all of the time limits before the inauguration of a new president, then it'll depend on who the president is. If Trump wins the election, they'll continue what they're already working on, and Daca will go away because his action in issuing an executive order was not improper. It was how that order was attempted to be carried out that was improper, at least according to the U.S. Supreme Court. So it'll all depend on what happens in the next election. Which brings me to the fact that it is really, really important that everybody who is eligible to vote, vote. If you are eligible to register to vote, but you are not registered, there are places to register. You can get the form, download the forms to register, fill them out, and mail them into the Tarrant County Elections Office, if you live in Tarrant County, or the elections office for the county where you live, to be eligible to vote in November. But you have to do it before the early part of October in order to qualify to vote in November. I would warn you that if you're renewing your license and you think, well, I'll just register to vote when I renew my license, it takes a long time for your application to get from the Motor Vehicles Department to the particular county, so it may or may not actually be valid in time for you to vote. There are no specific limits currently on executive orders, so long as those orders are given to administrative branch agencies in order to carry out matters that fall under the subject matter governed by that agency. That is, the president can't order Congress to do something by executive order. The president can't order the courts to do something by executive order. Executive orders can only instruct cabinet secretaries and the agencies they oversee and the agencies that fall under those cabinet level agencies to act. So he can issue an executive order to the Department of Treasury pertaining to the collection of payroll taxes, as an example. But since he does not have the power to set the tax rate unilaterally, that power is solely given to Congress. He cannot waive those payroll taxes or repeal the payroll taxes or make them go away. Only Congress can do that. The only thing he can do is create a way to do it. Executive orders can last forever unless there's a new law passed that changes what the president did, or if the order pertains to something or orders someone to do something that is in direct contravention of the law. Trump tried to sign an order that said they were going to terminate payroll taxes. Then he found out he couldn't do that. He was not allowed to do that. That was not one of his presidential privileges. So then he just declared a withholding holiday, basically a payroll tax holiday, but you still owe the taxes. I don't know about you, but most people would rather have their taxes withheld from their check rather than getting the extra money and then finding out in April that they owe a lot of money, or having to file estimated taxes because there was not enough money withheld to cover your taxes for the year. Any questions about administrative law before we talk about the materials of legal research? Thank you. Published legal resources can be divided. Yes, next tax season is going to be a lot of fun for a lot of people. It's going to be a very complicated season. Published materials, legal resources, can be divided into three broad categories: primary sources or authorities, secondary sources, and index search or finding tools. All of these published resources can appear in more than one format, including printed books, electronic databases, digital images, microforms, compact discs, videos, any other type of media. And many resources can contain more than one type of information. Some of our electronic resources contain both primary and secondary sources, and they serve as their own finding tools. Sort of a one-stop shop. Understanding how legal materials are structured and organized, regardless of the media, is necessary in order to effectively conduct legal research. Primary sources. These are authoritative statements of legal rules issued by governmental bodies. That's case opinions and rules of court, constitutions, legislation, that's statutes and codes, administrative rules and regulations, and administrative opinions, where the administrative agency is empowered to make decisions and to adjudicate disputes. Many primary sources are published in the order in which they are issued, with little or no indexing or other subject access to those resources, which means that secondary sources or an index search or finding tool is necessary to be able to access that information. Case law is published chronologically, and one case bears no relationship to the next case other than it comes from the same jurisdiction, but the subject matter has nothing to do with each other necessarily. Secondary sources are materials about the law used to explain, interpret, develop, locate, or update primary sources. The major types of secondary sources are treatises, restatements, loose leaf services, legislative histories, law reviews, and other legal periodicals, legal encyclopedias, American Law Report annotations, legal dictionaries. How persuasive a particular secondary source is likely to depend upon how it's created and what its intent is. A legal encyclopedia is a very, very useful secondary tool, especially for someone who does not have a lot of knowledge about the particular area of law. However, it is not considered to be a particularly authoritative secondary source. The encyclopedia is basically the law in breadth. They take a look at all areas of law, but just so deep, just a cursory level about it, as opposed to American Law Report annotations, which take an individual, very narrow point of law, and they dig down as deep as they can to demonstrate all of what's involved in that particular question of law or individual little point of law. And so because of how deep it digs down into the nitty-gritty of that law and its applicability, an ALR annotation can tend to be very persuasive because it gives you so much additional information and explanation and interpretation. How persuasive a secondary source will be depends on who wrote it, what the intent of the writing was, how carefully it was written and researched. Practice manuals, legal encyclopedias have little persuasive value but are highly useful working in the field. Many of the other things are very persuasive but may not be useful if you don't know anything about the area of law and all you really want to know is, how do we do this? You're just looking for some general direction about the area. You don't need something that's as authoritative as you do something that is informative. Index search and finding tools are publications that are created to help you locate cases, locate information, interpreting statutes, locate and update all of the individual types of materials you're looking at. So index search and finding tools include digests, which help you locate case law, annotations and annotated statutes and codes, which give you research references and cases that interpret and explain those laws. Citators, which are books that help you update both case law material and statutory material to determine what is in fact the law and how it applies. If you'll recall, we've discussed that when a case opinion is published, it's published. If that case goes up to a higher court and gets overturned, nobody goes back and stamps in the book overturned or cuts the case out of the book. It's just there. You have to be able to look to a finding tool like a citator to update, is this case still good law or did something change? Even when the individual case itself does not go up for further appeal, if the subject matter contained in that case is then heard at a higher level, it may no longer be good law because the court has changed what the law is. Occasionally, a court will actually alter their own decision. That is, a court can hold that a prior decision of the court is no longer valid because a new interpretation of the law or a recognition for how that ruling has now affected society determines that a different outcome is necessary. If you're researching segregation and you find the case Plessy versus Ferguson, it's in the books. It was decided in the 1880s. You can read Plessy. Plessy says that as it pertains to railroad sleeper cars, so long as equal accommodations are provided, you can segregate the accommodations and have separate accommodations so long as they are equal. And what constitutes equality is subject to interpretation. Fast forward to the early 1950s, and there was a group of cases brought pertaining to education, specifically to public education, and whether segregating schools and requiring children of different races to attend different schools created unequal education or unequal access to education. And in that time, the court ruled that the very operation in and of itself created inequality. And the court did so with one voice in Brown versus Board of Education et al. And the other cases that made up that case. Chief Justice Warren wrote that separate but equal is inherently unequal and sent the case back for further proceedings with instructions to legislatures and school boards to effectuate change. The court did not have the power to instruct the legislatures or the school boards on how to effectuate that change, not the court's purview, but to suggest or to recommend that changes be put into effect to alter the segregation of schools. Because the courts in that case did not have the power of enforcement, they couldn't force anybody to do something. After Brown was decided in the 50s and 60s and into the 70s, there were quite a number of federal lawsuits brought because school districts were not implementing the elimination of segregation. And in fact, a number of large school districts, including the Dallas Independent School District, were put under federal court supervision for failure to implement appropriately and timely a change in policy to eliminate segregated schools. And so until very, very recently, the Dallas Independent School District was under federal court supervision, where every time they wanted to change the attendance zone for a school or build a new school or create a new program, a magnet program or other type of program, the district had to go say, "Mother, may I," to the federal court judge overseeing their process and procedure to determine whether the actions they were choosing to take were in the furtherance of integrating the schools or would have a tendency toward creating greater separation or inequality of services and access to education on racial grounds. So you need those index searching tools. If you only have Plessy versus Ferguson and you don't have a citator or other tool to help you learn that after Plessy there was a new Supreme Court that expressly overturned Plessy, you don't know what the law is. If you don't know that while Brown versus Board of Education changed the rule of law, but did not cause enforcement of that law on individuals, then you don't have an understanding of the history of what happened with regard to school segregation in this country. You need to be able to shepherdize or otherwise use a citator to look up Brown versus Board of Education in order to locate the cases that came out later where the court assisted in the implementation of what was required by Brown as a result of the abdication, that is, the failure to act on the part of the individual school districts. So having those index search and finding tools assists you in locating that material and in updating what you found. Loose leaf services and computer-assisted legal research systems, Westlaw or LexisNexis, Nexus Uni, which is what we have, are among the most valuable finding tools. They have to be distinguished from other finding tools because they're not only a finding tool, but they also have available access full text to particular information, primary and, in many cases, secondary sources as well. In this country, publishing of legal materials has gone through a number of cycles. In the colonial period in our history, law books were extremely scarce. A large collection of law books could be 50 to 100 volumes and was predominantly English case opinions. As this country grew, expanded westward, and our economy shifted from agrarian to industrial, there were greater demands on our courts and legislatures, and the body of legal literature grew accordingly. There's been extraordinary growth in the quantity of primary legal materials that can be seen probably most clearly in the growth of case law. Just note that statutory materials have grown similarly, as have administrative law, that is, rules and regulations of the administrative agencies have also grown commensurate with the growth of society. But you see it most clearly in case law, where you can actually count cases, how many cases are published. From 1658 to 1896, courts in this country published 500,000 decisions. By 1990, there were 4 million reported decisions. So in less than 100 years, the number of reported decisions grew 8 times to be 8 times what had been created in well over 100 years before that. By the year 2000, an additional more than 2 million cases were decided, or up to 6 million cases. In 1950, about 2,100 cases were published. In the last several years, there's been an increase in the number of published cases year over year over year, and we're now averaging somewhere around 250,000 cases a year. So we're now publishing almost 250,000 new case opinions. That's all courts in all jurisdictions every year. That's a whole lot of legal material. In addition to the case law, Congress and the state legislatures produce huge amounts of statutory law, and the federal and state administrative agencies produce thousands of rulings and regulations. These authorities are published in multiple sources, and then there are lots of secondary sources and law-related materials that have expanded to commentate on the primary law and to explain, criticize, etc., the primary law. We do have official and unofficial publications. American Legal Resources, whether books or databases or other materials, can be divided into those that are considered official and those that are unofficial. Whether a publication is official or unofficial does not alter the nature of the authority. That is, case law is primary authority regardless of who publishes the book. The cases of the U.S. Supreme Court are published in the United States Reports, which is published by the Government Printing Office. That is the official source of the decisions of the U.S. Supreme Court. In addition, Thomson Reuters, through their West imprint, publishes the Supreme Court Reporter. That's a private publisher publishing the cases of the U.S. Supreme Court. The content of the books, that is the case opinions, are still primary law, but the publication itself is unofficial because it's a private publisher, not the government, not as ordered by the government or authorized by the government. In addition, we have a third publication of the cases of the U.S. Supreme Court in the U.S. Supreme Court Reports Lawyers Edition. That one's published by Lexis Law Publishing. Here again, it's a privately published reporter, but the content of the reporter is primary. So even though it is an unofficial publication, it is still very much a primary authority. In many cases, the benefit of unofficial publications, whether they're case law or statutory law or administrative materials, is speed. That is, the private publishers generally get their materials published more quickly than the government does. And so, for the most part, you will often find that the private publication is more up to date. The unofficial publication is more up to date than the official publication, and so more highly prized in terms of being sure that you've gotten all the up-to-date information about the particular subject you're looking at. Official publications can be produced by the government themselves or can be produced by a commercial entity under contract to the government or by license from the government. So sometimes, even when privately published, it's official because the particular publication is authorized by the government. Otherwise, it's just considered to be unofficial, but still primary. Law publishers in this country used to be fairly prolific, but starting in the 1990s, we had a significant period of mergers and acquisitions and consolidation in publishing to where we now have just a very few number of publishers, even though the imprint names under which they publish still exist. The largest publisher of legal information is the Thomson Reuters Corporation. This corporation used to be called ITP Thompson's. Then they bought the West Publishing Company and created the West Group. ITP Thompson's was a Canadian corporation that acquired West Publishing Company, which was an American corporation, a Minnesota company, and then they merged with the Reuters Company, which was both a news service and the publisher of significant publications dealing with tax law. So we now have Thomson Reuters. They publish under a variety of imprint names. So publications from Thomson Reuters include books and other materials published under the trade names Bancroft Whitney, Banks Baldwin, Clark Boardman Callahan, Foundation Press, Lawyers Cooperative Publishing, Thomson West, West Publishing, and West Group. They also publish the Westlaw database. Other commercial legal publishers include West Academic, which is a spin-off of Thomson Reuters. They publish under West Academic Publishing, Foundation Press, and Gilbert's. Your legal research textbook is a Foundation Press imprint from West Academic. Reed Elsevier owns and publishes under the names Anderson, Butterworth, Lexis Law Publishing, LexisNexis, Matthew Bender, and Shepard's. Walters Kluwer Law and Business publishes under Aspen and CCH. And what was formerly the Bureau of National Affairs, or BNA, is now owned by Bloomberg News, and they now publish Bloomberg BNA. Not a lot of publishers. What that means for practitioners in the legal field and anyone studying any area of law or to work in the legal field is that there's such a few number of publishers, pretty much the companies can charge what the market will bear, which is why textbooks in the legal field are so expensive, because there's not a lot of competition. The changing structure of legal publishers has also changed the way in which some materials are published. Some materials that used to be in hardcover are now paperback. Some that used to be hardcover and supplemented are now on a loose leaf platform to assist in updating the materials. More and more materials are available electronically through Westlaw or LexisNexis or Hein Online or other databases, and so we'll learn what materials that you need to use in print are also available electronically in order to locate and research particular subject matter areas. When inspecting and evaluating legal resources, it's important to understand the purpose of the resource. I always recommend when you start using a new set of books that you read the introduction, the beginning of the book, where it explains how to use the book and what it was created for. Having that additional information can be very, very useful in figuring out how to utilize the book and how it fits into the research that you are about to perform. Legal research and the ability to do legal research is considered an essential skill for lawyers and is also equally an essential skill for paralegals. Professional accrediting and licensing organizations have recognized that the ability to perform legal research is an important practice skill. The National Conference of Bar Examiners sponsored a detailed study to determine the relative importance to newly licensed attorneys of different areas of law. Legal research came in 5th out of, 86 areas of law. That's the top 10%. That's a pretty significant and important area. This program is approved by the American Bar Association. That is, they have reviewed in detail what we teach and how we teach and approved of how we do it, given their imprimatur on our program. We get to say we are ABA approved because we've gone through the accreditation process. Their accreditation process includes a requirement that we teach legal research, both through the traditional books and electronically, to give you full and complete access to the knowledge of how to conduct legal research. Learning how to do research in the books as well as utilizing electronic means is really important because a large percentage of the state of Texas is rural and is small law firms, not big law firms, and the electronic databases cost a lot of money. And so if you work for a small firm or you work in a small town, it is highly likely that the legal research you are doing, you will have to do utilizing books either in your law firm's library or more likely in the county law library, and to know how to use those materials. But the ability to do legal research is considered to be an essential skill, one of those fundamental skills that all practitioners in the field need to know. And as more and more lawyers take on more work and hire paralegals to do a lot of the work that formerly was performed by lawyers, it has become more and more important that paralegals have a full and complete knowledge of the tools of legal research and the ability to perform legal research. The ABA's model rules of professional conduct provide a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for representation. In order to be fully competent, prepared, and knowledgeable, you have to be able to do the research to know what the law is. Good lawyers don't memorize the law. They memorize where to find the law. The key is to be sure that you know where to locate the materials and you know what types of materials you're dealing with to ensure that you have the ability to locate the information that you need, hopefully at a moment's notice. We're going to spend this semester learning how to utilize not only the books but also the electronic databases to give you full and complete access to those materials. Any questions? Well, this is where I ended my class Monday, Wednesday morning, and also this morning. And so I will not continue to Chapter 2 at this time so that we can keep all of the classes on the same schedule. For next time, please read Chapters 2 and 3. I don't think we'll get to Chapter 3 yet, but I would prefer that you go ahead and start to read it if you have it available, in case we do go faster. If your book has still not come in, you can email me. If I have not yet sent you Chapter 2, I will be happy to do that. If you already have Chapters 1 and 2, but you would like Chapter 3, if you will email me, I will individually send you out Chapter 3 while we are waiting for books to come in. 7th edition, instead of The current edition is a huge problem. Our current edition is the 10th edition. It has been significantly revised on multiple occasions since the 7th edition. Sarah, I would see if you can't return the book because you got the wrong book. And then do some looking for the 10th edition. I do know that the publisher has both. Oh, I understand you thought what you were getting was the 10th. That's why I'm saying, since what you got is not what you thought you were purchasing, I would attempt to return it because they didn't send you the right thing. The publisher, West Academic, has a website that you can buy from directly. The new book is $113. The new book in ebook form is $84 and change. This book is also available for rent several places, and there are additional copies. This edition, this 10th edition, has been out for quite some time. That is, I'm going to say, well, this says at least 2015, which is what my recollection was, that's when the West Academic update was published. Given when the 10th edition was issued, should be a lot of used books out there as well. But as I say, even as a new book, the book itself is, comparatively speaking, not that expensive, and it is also available in ebook form. In the meantime, if you don't have the chapters that you need, if you need chapter 2 or chapter 3, or both, if you'll email me, I will send those out. I've been trying to send those out at least 2 or 3 times a day as I get emails from students. I'm probably not checking my email again tonight, but I will send them out tomorrow, probably right after my 11 o'clock class, which finishes at 12:30. Normally, I would try to get to things, but I didn't get much time off between end of office hours at 3 o'clock and class at 6:30. So I've been doing this virtually continuously since 9:30 this morning. And I'm going to take a break. Does anybody have any additional questions before I conclude the class?